Okay, perfect.
Hey, Pat, just one. Jennifer, can you say your last name?
Monthie.
Monthie. All right, great, thanks.
You show up as Jennifer Livingston on the screen. So.
Oh, let me change that. That's my married name. Hold on.
All right. Well, welcome everyone. Welcome, particularly to our guest speakers, and thank you to you. There's a lot of familiar faces that I see on the screen, or that I did until we just turned the nature of the screenshot away. To the admitted students who are our guests, welcome. I hope you'll get a flavor of the intellectual life here, which exists in so many ways, but First Monday is one of them. To all the students, thank you for coming back, and thank you for coming for the first time. And of course, to the alumni, thank you for coming back. First Mondays is a program that's in its second year. We were renewed for this season. And the whole idea of First Mondays is that there's so many things going on out there in the world. Political things, hot political topics, hot cultural topics, hot, as we know from our last session on Reddit and GameStop and that sort of thing, hot economic topics. And they're all in the news and we're being bombarded by it, but we don't really get a chance to sit back and think about what the law has to say about it. In kind of a calm, cool, and collected way. We wanted an opportunity to shed light on the essential news items of our day. Now, the problems of Britney Spears is not really an essential news item of our day, but the problem writ large is, and particularly with an aging population, the problem writ large is. So we couldn't be happier to welcome two experts to this subject. And as I told all my students in encouraging them to come, I believe this is a subject that anyone with the letters ESQ after their name should know something about. We may need to know about it in our law practice, but we're surely going to be asked about it in our lives because we're lawyers and people. This is a human concern. It's a place where law and humanity really come together. So with that, Ted, it's all yours.
Great. Thanks, Pat, and welcome everyone. This is really exciting. I share Pat's enthusiasm and Professor Reyhan's enthusiasm for this series and for this event in particular. Just two acknowledgments on my end to Kate Seeley-Kirk, that's my work companion and my wife, for suggesting the idea over lunch one day, and to my mother-in-law Judy Kirk, who listens to these podcasts. Hello, thanks for tuning in. So the topic is, I think, important for several reasons, not just because sort of everything 1990s is in style again right now. And I was someone who grew up with Britney Spears music and watched her videos on MTV. So I'm excited to see, for personal reasons, to see the 90s coming back so much. But because this topic, with respect to guardianship and conservatorship, is so important in the lives of individuals who go through it. And we, to draw a connection to other events we've been talking about on campus recently, the Nancy Sills lecture that we had last month in February on the topic of approaching elder law as a civil right, I think also leads into this conversation very well. We all have to deal with these issues in our own lives and with clients and with friends and family too. So it's important to discuss and consider. We're really fortunate to have such a deep bench of expertise in this area. So we welcome two experts this month. The first is Jennifer Monthie, who's a class of 2003. Jennifer is the legal director of Disability Rights New York, which is a nonprofit legal services organization based in the Capital Region, but working statewide. And Jennifer will kick things off and frame the conversation with respect to the conservatorship process, sort of a comparative approach. What's happening in California in the Britney Spears case? How is that similar or different to what would happen here in New York? And our second expert who will chime in and present too is Professor Rosemary Bailey, who teaches elder law and is involved in the Government Law Center and specifically our Aging Law Institute. So we welcome Jennifer and Rosemary to take things away and to lead us and guide our conversation.
Well, thank you. And I'll go first. So, and then you jump in, Rosemary, where you need to jump in. As was said, I work for Disability Rights New York. Just to clarify, we have offices in Albany, but we also have offices in Brooklyn and Rochester. So we do cover the state, and we're called upon quite frequently where guardianship is raised. We do quite a bit of representation in trying to restore the rights of people who have been placed under guardianship, because our entire office provides representation to people with disabilities, not necessarily family members on behalf of who might be seeking guardianship, but people with disabilities who in some circumstances are placed under guardianship. I thought it would be good to frame just what happens in New York and contrast it a little bit with what happens in California. So in New York has basically two guardianship statutes. And while California calls it conservatorship, New York calls it guardianship. And in essence, it's the same thing. It's the ability to get decision-making authority, both in the personal realm and the financial realm, over a person who has been determined by the courts to be incapacitated. In New York, we have a guardianship statute that is exclusively for people with intellectual and developmental disabilities. It's called Article 17A of the Surrogate Court Procedure Act. And we also have a guardianship statute which really covers, in addition to that population, anybody else. So that could be somebody who is aging and someone is asserting that they've lost capacity, or someone with another type of disability, for example, a serious mental illness. And that one is called Article 81 of the Mental Hygiene Law. Something to really understand about both of them is that the crafting of both of those statutes happened at different times. Article 17A happened much earlier in the 60s, and Article 81 was in response to some concerns about the then existing conservatorship system in New York in the 90s, and the statute was crafted to respond to some of those concerns. Most of those concerns related to the lack of due process that existed and some concerns about abuse that was happening within the conservatorship. So Article 81 is driven, and Rosemary Bailey, this is a testament to your legacy, right? Driven to due process. So how do we ensure that the rights of the person who is being placed under guardianship have been protected through the process, through notice, through representation, through the standard of removal of their decision-making rights and placing them with another. So you'll notice under that statute, if you delve into it, that there's a lot more discussion about ensuring that the person knows that the proceeding is happening, ensuring that a proceeding doesn't happen without them being present unless there's a very exceptional circumstance, and a standard that talks about when a guardianship can be appointed. For example, a person who the court needs to demonstrate that the personal needs or property management of the person can adequately understand it and appreciate the consequences of the removal. And there's a harm standard there that they would be harmed if the court did not act. In the contrasting Article 17A, there is a best interest standard. Would the person be better off is almost the issue. And the only proof needed is to demonstrate through certifications of a physician or a psychologist or both that they have a developmental disability. So these two statutes I raise in New York only because there are multiple statutes in California under their conservatorship. They also have a conservatorship that is targeted to people with intellectual and developmental disabilities is how they define it in California. And then they have this general probate conservatorship that they place over all other people. And then they have a guardianship that they limit it to gravely disabled persons due to mental disorders. And it seems to be that they're targeting people who require psychiatric hospitalization. So their guardianship system, like New York's, is really broken down by the nature of a person's disability. What I find slightly different about their general guardianship that applies to most people is that the standard is, and I'll quote here, unable to provide for their personal needs due to physical injury, dementia, or other reasons rendering them incapable of caring for themselves or making them subject to undue influence. And I think that is the area that we're probably going to see why the court got involved with the Britney Spears conservatorship, this undue influence. The standard under Article 81 is a much higher standard than that. It isn't about undue influence. It's about that person and that harm to that person, which does hopefully, the intent behind it was limiting the number of people who were placed under guardianship or being placed at risk of being placed under guardianship in New York. The best interest standard of Article 78, that undue influence is inherent in that process, protection of that person. So we see guardianship in the Article 78 proceeding being this, unknown standard of how or why a court might decide to put somebody underneath a guardianship. I'm going to pause just for a second, so I'll let Rosemary jump in because I didn't really get into the specifics of the statute. And if there's something that you want to add about the specifics, I thought there was I was just looking for a general overview so people could ask some questions. But go ahead, Rosemary.
Thanks, Jennifer. I think to underscore what Jennifer said, there's a tension really in any guardianship between the desire on the petitioner's end to advocate protection, what's in the best interest of the person, and the individual who's going to be the subject of the guardianship. Wait a second, what are you taking my rights away for? Why do I need this? Even for people who may be behaving in ways that the petitioner, the family thinks are erratic, they may have perfectly good reasons why they think they're doing what they're doing, or they're just feeling that this is the way they want to live their lives. And what's interesting in New York is we have two statutes that actually reflect those two different points of view. As Jennifer said, the Surrogate Court Procedure Act, which is limited to people with developmental and intellectual disabilities, is totally paternalistic, totally in the best interest. We're not really interested in what the person has to say. The Article 81 under the mental hygiene law is, if anything, the reverse. We're really looking at the autonomy of the individual, and it's only when there's clear and convincing evidence that the person is going to come to harm because they don't understand the fact of the way their behaviors, which are limited by some condition, are going to cause them harm. And so the court has really a totally different focus in the two statutes. And Jennifer and I could spend a lot of time on why they're the way they are. It's a historic thing as much as anything else, but, and we could advocate for why the surrogate court statutes needs to be changed. But I was gonna suggest maybe that Jennifer wants to talk about one of the critical differences, and one that also I think comes into play with Britney Spears, is the ability to get out from under the guardianship. We can talk a little bit about why you even need to get to guardianship court, but if you've got a guardian, the standard by which you can get out from under it, and the two statutes again reflect totally different philosophies about it. And I think that Britney Spears is in that where she wants to get out from under the conservatorship. So back to you, Jennifer.
Yeah, I agree with you. And I did a little bit of research, right? I'm a New York practitioner, not a California practitioner. So if there's anybody out there that practices in California, I have a limited knowledge of the California statute. But what I will say is that my office has done quite a bit of work with restoring people's rights under Article 78, which really that has many barriers to removing a guardianship. It did not envision when it was created that there was such a thing as a removal, but our constitutional rights and due process demands that be available to people who want to restore their rights. So the system has been unfolding, and the process of unfolding through practitioner efforts to demonstrate to courts that such a process needs to exist. And I only raise that because when I was looking at the conservatorship process in California, the first thing that I saw when I went to the court's website is very similar to what you see when you go to the New York court site. website on Article 78, it starts with a question about restoring the rights of people under conservatorship. And the first thing it mentions is that this is not expected to be removed. It would be an unlikely thing, or I'm not sure the word they use, but the expectation is that the conservatorship, just like the guardianship under Article 78, is a lifelong endeavor once you place a person under conservatorship. And so we found the same thing when we were doing advocacy within Article 78. We had to essentially go to each surrogate court and explore the process for removal, which is something that we got divergent responses to. Some of them said you don't have standing to bring a petition if you're already under guardianship because your rights have already been terminated. So you can't in fact ask that the guardianship be removed. Others didn't know what the process was. Some of them granted guardianship with no record. So there's no objection at the first placing a person under guardianship. So there's no reason to develop a record or no requirement on a petitioner's part to develop a record. So it becomes the person under guardianship's responsibility to fully develop a record after they've already been placed under the guardianship. And I see the same mirroring process in the conservatorship in California. And one thing that I was struck by when I watched the documentary was this comment from an attorney that Britney Spears had sought legal advice from when the emergency petition was in place, or the emergency conservatorship was in place. There was a statement that said she acknowledged that she couldn't fight it, and so she needed to participate in the process. And that's consistent. There is this there is a process in place that once the petition has started, the ability to stop it in its tracks becomes very difficult. And so you don't have a record. You essentially consent to the placement of yourself under a conservatorship or guardianship, and there's no demonstration of the reasons why you're placed under that. So that when you go back and try to restore your rights, there's no way to say, see, that doesn't exist anymore. I'm able to make decisions now because the consenting process gives you no record to fight against. There's no allegation that you can then provide evidence to that it no longer exists. And that's the difference between, there is an ability to essentially waive the process under Article 81, but the development of the record, the jurisdictional portion of it, does a court have jurisdiction to place you under guardianship, does require some development, some allegations that there is a lack of ability for that person to protect themselves, and therefore the court must intercede so that when a person comes back and says, I'm ready to have my rights restored, there is a basis for the court to contemplate whether those allegations still exist. The other thing I will mention is specifically in the statute, not only is there a right to counsel and a counsel of your choice, which is another area of the Britney Spears documentary where she couldn't get the lawyer that she wanted, she had to get the court-appointed lawyer. That is already written into Article 81. And then there's also within Article 81 a provision to talk about terminating the guardianship. That doesn't exist in very many conservator or guardianship statutes that were drafted before the 1990s and 2000s. And most of those restoration provisions were drafted once there was a recognition that a person with a disability might regain their capacity, and that keeping somebody under a guardianship for their entire life would violate their constitutional rights. So I'll stop there. I don't know, Rosemary, if you want to.
So I actually had a couple of things I wanted to add to. One, interestingly enough, Article 81 specifically allows for a motion to dismiss the guardianship. So it contemplates the idea that it could end before it even starts if there's a motion brought to do it. Secondly, it also requires the petitioner to look at whether there's something less restrictive than guardianship, which doesn't exist in the 17A guardianship statute, which says the petitioner must come to court and make allegations that they've considered other options for handling the situation, and none of them are sufficient and reliable. So it sort of says, okay, look at whether there's alternatives. They may not work, but you have to have done that. And that may be a basis for dismissing the petition because the court has, through its investigation by a court evaluator, determined that there is something less. And in fact, and we can get into the weeds here, the court can actually fashion something less restrictive to the guardianship. And the one last thing I would mention is that even with counsel, there's no doubt in my mind that the statute is really protective of the individual, and protective in the sense of protective of their rights. Because in many of these cases, believe it or not, the petitioner may offer to pay for a lawyer for the individual, and the court investigates whether that lawyer, which is okay, I mean, under the ethical rules, that can happen, but the court will examine whether the attorney is acting independently of the person who's paying their bills, so that the individual's rights are protected. So again, it really focuses on the individual. Oh, and the last thing to mention, and this is really, again, the whole idea of removing the guardianship, the burden is on the person who wants to retain the guardianship. So the individual doesn't have to come forward and prove that they have been, they're now perfectly restored and they can act however they're supposed to be acting. The burden is on the family member or the guardian or somebody else to say, no, and they have to do it by clear and convincing evidence. So it's a high burden. So all in all, it works to the benefit of the individual who's trying to get out from under the guardianship.
I can't stress enough how important that burden shifting is in the 17A proceedings, even when the guardian is no longer seeking to retain guardianship, we still must prove that it is in the best interest of the person to the court to remove that guardianship. And I'll just mention one aspect of this is that when there is a lot of money at stake, guardianship is a much more complicated thing to remove, in my opinion, because there is an entire industry surrounded by this guardianship process. The person under guardianship is often funding everyone's attorney in the proceeding, including the court's attorney in the proceeding, and what many people, if you look at some of the other guardianship abuses that occurred in Nevada and Florida, the person gets to the point where they no longer challenge the process because they're being billed so much every time they challenge the removal of the guardianship that their estate is being reduced at every challenge. And so that is one of those things that we have to constantly think about when you craft such a system that does permit, which New York does too, permit the court to allow the person's estate to be charged when in a guardianship. So there is a financial decision that people, even under guardianship, have to make about removing a guardianship and how much money it's going to cost them to remove that guardianship.
Could I ask a couple of very quick questions? This is fascinating with respect to, I had not thought about the fact of the legal problem for a person under a guardianship seeking to have the guardianship removed when by definition they are incapacitated. But from what I'm hearing from the two of you, in New York, we've somewhat overcome that. That is, the person under the guardianship is not barred ab initio from raising this issue. And the second quick question, and then I'll mute myself, is would New York have, as I understand what happened to Britney Spears, is she went, as a result of fame too early and a terrible marriage and responsibility of 2 children. She didn't handle that very well. She definitely just kind of went off the cliff there for a while. And if in New York doesn't have that category, Jennifer, that you described. That's kind of, well, if we need a guardianship, we can create one. I don't think. Would Britney have been put under the guardianship initially, as you understand it, had this been in New York and not California?
New York, there needs to be some functional, if we're talking about Article 81, there needs to be some functional assessment of capacity. Generally, what we're missing in terms of the facts are diagnosis of a mental health condition in Britney's case. There does appear to be a court evaluation that was done and used in a temporary conservatorship proceeding, enough for the court to believe that someone needed to step in. It would be surprising to me if there was not some form of a diagnosis that occurred that preceded the application. But it's possible in California that exists, and all you need is a person that is being placed under undue influence without a secondary diagnosis. In New York, I think that there would be it would be challenging to get the Supreme Court to issue a guardianship without some form of a diagnosis.
And
Functional capacity analysis as well.
Right.
Go ahead, Rosemary.
no, I was just going to say, and I'm glad you brought that up, Pat, because in New York's, the case is Rivers v. Katz, and I don't have the site with me, but I'll send it out. It goes back much earlier, it predates actually the Article 81 guardianship. And there the court, the individuals were involuntarily committed, and because on the basis of the mental health diagnosis. And the state hospital wanted to medicate these individuals over their objection. And they were adamant about it. And it went all the way up to the Court of Appeals, and the Court of Appeals said, mental illness alone is not enough for this. They could still object. Even, I mean, I love this case because when you read it, you say, wow, that mental illness alone, and even the fact they were involuntarily committed, is not enough to override their objection. And even, this is the best part, even if the state can show that they really should be medicated, they have to show that it's the least restrictive way to accomplish the restoration of this person's treatment, or this treatment. And so that is imbued through, so even her diagnosis alone in New York wouldn't get her a guardianship. There has to be something more than that, which I think is really well, I favor that approach because it says, you know, if and this is what was the problem under the old law and is the problem under 17A. A court gets a piece of paper and it says this person has schizophrenia or has bipolar disorder. And you can know what goes through people's minds, and judges are not immune to this. They look at that and go, whoa, that they need a guardian or they need a conservator. Doesn't work. They have to show that somehow this individual can't function and that there's harm that's going to come to them by reason of that. So it's beyond the mental illness. Anyway.
I wonder if I could add a question or two as well, and then maybe invite participants. You know, we have around 70, 75 participants in the room, but there's just two things that I'm curious about. I imagine in situations where there's a significant resources at play, like with Britney Spears, I guess, is it typical to have a co-conservatorship or guardianship model? You know, someone to watch over financial assets, someone to watch over sort of, you know, so in the instance here where someone has a significant entertainment career, you know, is that typical? And then also, I some of the, you know, reading that I did was, how do things work across multiple jurisdictions? It seems like the father in this case was trying to extend conservatorship or guardianship beyond just California. So I imagine, you know, imagine someone seeking that type of control has to do a state-by-state approach. But, you know, I imagine there's a lot that's untypical in this particular case because of the individual and her career. But I wonder, you know, to what extent these might be similar.
I'll do the reciprocity second, and so the first about co-guardians or co-conservators, there are I've seen that set up. So you might have somebody of the person and someone of the property. When you have probably this high of an estate, it's not unlikely to see a bank or a financial institution involved in being, you know, a guardian or a conservator. And it's it's also when you do go that route, it's not unlikely to see a person that is a family member serve as the guardian of the person to make medical decisions. So that does occur. Reciprocity is kind of a good question. What we have seen more is, no, you don't need to go get a guardianship in every state. There is an acceptance that if a court in California were to place a person under guardianship and transactions needed to happen in another state, that person has, the conservator or guardianship has the authority to engage in that transaction. So you don't need to get a guardianship in all 52 states and territories in order to act in that role.
Yeah, there's a provisions in the mental hygiene law that covers that, because that can happen for any number of reasons where a person could have property in more than one state. In the past, New York has been relatively skeptical of guardianships awarded in other states where they deem the protections of the individual to be inadequate. So it's not necessarily full faith and credit all the time for other guardians that are appointed.
While we're waiting for questions to come in, what I found fascinating about the California process is this temporary guardianship where the person does not even have to be notified that they've been placed under a guardianship. I don't know what your reaction to whether when 81 was crafted, whether there was some talk about needing to, I have not, it certainly isn't happening in New York that way. There's this very strong effort to have the guardianship proceeding wherever the person is, if it's under 81, so that even if you needed an emergency guardianship, the court would essentially conduct the proceeding in the hospital right next to the person. And it does look like California has this ex parte guardianship process, which seems unbelievable to me, given the deprivation of liberty that occurs, particularly when guardianship, and I don't know what the rate of essentially temporary conservator to permanent, what that rate, exchange is. But I do know that when courts make a decision to go back to that same court and have a different outcome from a judge, essentially saying, nope, it's not really needed. I can see that not being an effective process, which may have led to I understand I can't fight this anymore. I've got to participate in the process.
It's true. So the idea of, and it still provides the statute in Article 81. Notice how we're not even talking about Article 17A, because really personally abandoned it as a way to protect individuals. But under Article 81, the court is required to hold the hearing where the person is, unless there are some really extreme circumstances which would would argue against it. The idea there was what I said earlier, that the courts under previous practices were looking at affidavits of physicians and saying, oh, this person's got this, they need a guardian, we don't need to see them, when in fact, the diagnosis doesn't tell you anything except that's a diagnosis that the person has. And I lost my train of thought on the second part of it. Let's see, they were, anyway, it'll come back to me, but definitely important that the court see the individual when all is well. Oh, I know what it was. The idea that you could have a temporary guardian appointed without a hearing. The Court of Appeals case, there's a case of Fossmeyer v. Niccolo that mitigates against that. The relief that was sought there was ex parte, and the court said, hey, we have phones. Let's get the lawyer for the individual on the phone and talk before we grant any relief. And while Article 81 doesn't spell out that there has to be a hearing, the Court of Appeals decision is right there to say there has to be something, it can't be done ex parte. So.
Ms. Reyhan, you have your hand raised.
Sorry, thank you so much for doing this presentation. I do have a question about factors that could lead a court to decide whether or not a like a person is capable of controlling their own assets and things like that. In Britney's case, I know that she's under a temporary conservatorship, but she's also during that conservatorship until recently was performing and was creating music and was, you know, making public appearances. How would that feed into them deciding whether or not she should have a conservatorship, and how come she's still under a conservatorship if it seems like up until recently, when she's decided not to perform under her father's control, that she was still performing at this like super high kind of elite performance level?
Yeah, I think those are good questions. Not knowing the California and the role, the only thing that I could probably turn to is the provision that says, or making them subject to undue influence. So it is possible that it isn't about the capacity to make decisions. It could be the court is looking at a history, or there's evidence that the conservator is presenting that the person could still be placed under undue influence based upon who the person is associating with. I did find it really interesting when they did talk about in the Britney Spears case, this like, I'm refusing to perform until. I think it would be very challenging under any guardianship process to assert as a guardian or conservator that you can force a person to work. So I think that that it would be difficult to say that you have the authority to demand that they engage in gainful work as a conservator. And so that is probably a decision, even though it looks like the conservatorship is a plenary one where all authority is given to another person over this performer, that it would be very challenging to use the conservator process or the guardianship process to demand the person engage in gainful employment. That's really not how guardianship statutes are set up. I will say though, when we've been involved in cases that involve finances, and the ones that I can think of under the 81 provision, it isn't the aging population where you get, you know, this case law from. It is a challenge of people who are generally younger, where there's a lot of money. Maybe somebody got something out of a settlement. Maybe they have a traumatic brain injury. Maybe they have some mental health concerns. I have seen people with alleged to have intellectual developmental disabilities that are brought into the Article 81 court because the 17A court does not believe that they should fall under their jurisdiction, particularly when there's a lot of money involved. And the things that the court looks at are, you know, very protectionist, you know, trying to maintain the estate. And one of the things that struck out to me with the comments that were made were about how the value of the estate in Britney Spears' case has grown since Britney Spears was placed under conservatorship. And that is, you know, that is a factor that I think I see courts looking at is a person, even though New York has a clear and convincing standard that says that you have to prove the person needs to be under guardianship still, there is this in most places, and this tendency to fall back on, is the person better off? Will they be better off having a third party make a decision versus themselves make a decision? And that seems to be when guardianship is built out of a best interest standard, no matter how much statute you put in place to say we're not trying to do that here, that is the sense. It's a protectionist process. And so when you're presented with $1 million estate that's been growing and which was losing money before placing a person under a conservatorship, I think it is challenging to say, no, I can do it. And yeah, I'll lose money doing it, but it's my money and I can lose it. The courts are less inclined to agree with a person who has been placed under a conservatorship, that it's always better to have somebody else kind of manage the money. What we've had to do in order to get property removed is essentially advise clients to put money in trusts, to have powers of attorneys. They have to cede some of their independence in losing their money in order to remove a guardianship or conservatorship. And that's because that process, no matter how much due process you put in place, you still have a judge at the end of the day. And I do believe that with the court systems that we have, the courts we have in place, they're risk averse and they're not interested in seeing somebody lose millions of dollars or whatever their estate might be, that the process, that it's better to give somebody else the authority and have this person have somebody else take care of it than to risk having it lost.
Ed has a question that's come in over the chat, and then Ms. Butler, we'll turn to you after that.
Great. So talking about sort of the role of the judge here, we have a question coming in. Since the entire process is essentially a bench trial, do judges often, in your experience, Jennifer and Rosemary, err on the side of caution to avoid something like a judicial reprimand? Are there what-if factors at play? For example, we've seen deaths of great actors or entertainers, Jim Belushi, Jim Morrison, River Phoenix, and others. Is there sort of an approach from the bench that they want to err on the side of caution, so to speak?
I think it depends on, could I envision somebody in those male people's lives going to court and saying, let me take decision making away from them because I'm a better decision maker than they are? I mean, there are some circumstances of, I'm seeing it more in youth, and I think her age and her gender played into a decision to have somebody else make a decision for her, in my opinion. But no, I think judges look at the case before them, and we have to ask why that case ended up in front of them versus another case ended up in front of them. And each case, I do believe they look at, and it's very hard not to say, I can rescue this person or I can save this person. And to feel like you're a part of that rescuing. There is a part of our culture that finds it very difficult for people to have dignity of risk. And depending on the nature of the person, whether they're aging or whether they have a disability that's in even higher risk for some people. And so, you have to accept dignity of risk, that people can make, is the person making a decision knowing the consequences of their decision, even though it's a bad decision? And are we gonna let that happen? And I do think when you get a court proceeding involved, there is more of a concern about dignity of risk, because it's a judge, and the judge is going to be held accountable for, they found this person on the street and they're no longer living, right? And they've lost all their money. And so that is built into our system, that protectionist, that's what this is. It's a protectionist system. So once you start that process, I think there's a hesitancy to say, go away. The person knows what they're doing and they can go blow all their money and, die on the streets.
Rosemary, did you want to weigh in, or shall I
So
go?
thanks, Pat. I was just going to say, and this sort of goes back to what you said about the person once they're under guardianship, it's like over with. In New York, they can appeal the results in the court. And so there is the appellate court looking back at what the trial court did and reversing. And it's not uncommon for the trial court to have misread the situation or done it with an inadequate record or relied too heavily on information that was biased against the individual. So I think that's really important as well. And I just think this goes back to that earlier question about Britney Spears being a very active performer and musician and artist even after this conservatorship. I think the amount of money definitely plays a role here, because the first thing that occurred to me is, I wonder what she would do if she was out from under the conservatorship. And I have no idea, but it just occurs to me that the court is more persuaded by what the conservators are telling it than whatever her lawyers are saying at this point.
Ms. Butler?
Yeah, so I was just wondering, I know in Britney Spears' case that she really had no relationship with her father before the conservatorship. So I was just wondering what kind of evaluation the court makes to determine who the guardian should be. And then especially now that Britney's saying she won't perform unless her father's removed, if there's any sort of reevaluation process where he could be removed and maybe a different person appointed as her guardian.
So I'll say it depends on the statute in terms of what evaluation the court has to do before appointing a conservator or a guardian. There is no there is a list of people who can apply for guardianship under an Article 17A, and there's no evaluation of the effectiveness of the guardianship beforehand. Article 81, correct me if I'm wrong, there is this choice element that is added into it. There's a list, and then there's the person who's placed under guardianship has some voice there as well, but generally the list is sufficient. If a person is under, it looks like in California it runs very similar. There's a list, so the person, it doesn't matter whether they didn't have contact before, they could still be placed under a conservatorship. What we find in my experience, when there is a kind of unknown actor coming in to try to take guardianship, we see that there generally is somebody that the person knows that comes in and says, no, make me the guardian, which, was kind of interesting that it didn't happen initially with, I think, her mother coming in, but we've seen that scenario where you have other family members who come forward. It does make it a much more complicated process. And I think then there is an evaluation of who is better suited. But if there's only one person stepping up and the person is above the age of 18 and I guess not a felon and, can serve in that role, then it's more often than not that finding someone to serve as a guardian or conservator is a problem for the court. And they'd rather have it somebody that supposedly has some connection to a person's life than somebody off of a list, which is really what they would go to next, is someone off of a list. In terms of removing an existing guardian and or conservator and placing another one, if they've been acting in that role for a while, I think the courts disfavor the removal of that continuity. They might take it into consideration, but and in the Article 81 proceeding, given where the statute is, I think they would actually take it into consideration and want to find out why. One of the roles of the guardian is to try to work with the person under guardianship to increase their rights so they don't need to be, or can increase their decision making and their participation so they can have a lesser restrictive guardianship. And so if I saw a petition where the person's like, I will not work with this person, I don't like this person, and I'm proposing somebody else to work with, you may get some favor with the court to contemplate whether the guardian could act in those roles of reducing the tailoring of the guardianship with the current guardian. They'd at least, I think, consider it. In this case, it's interesting, the limited guardianship for people with IDD, or limited conservatorship for people with IDD in California, has that responsibility of the conservator working with the person to try to restore their decision making. That provision was crafted after the general probate conservatorship, which is kind of the opposite of New York. So you see this, at least on paper, trying to have an effort of working with the person. But I don't see that in the general probate conservatorship in California. So I don't know how much weight is given to the people who are under conservatorship when they disfavor their conservatorship. It might be something that the courts hear a lot and just ignore. And it does seem like the latest proceeding, not expanding the rights of the father conservatorship and kind of sharing it with a financial institution, might lead me to think the court is listening more to her attorneys than they have in the past. But who knows, maybe it's just wanting a financial institution involved because it's so much money, and one person serving in that role who doesn't have that type of background is not what the court is looking for with an estate this large. So I don't like to read anything too much into it. I think if you're wondering how you swap conservators or guardians, you really have to look at the statute. And if you look at the statute, you're going to see the ones that really have a specific reference to that person choosing are going to be more likely to have the person, even after they're placed under guardianship or conservatorship, have a voice.
So I could just add that Article 81 does have a list, but if you read the case law, it despite the list, the courts favor family. Even family where it's allegations that the family member would be a dubious choice. The courts favor family and often will structure requirements on the guardian to sort of say, well, you're gonna have to do some accounting to the court, which I sort of wanted to add two things to what Jennifer said. In New York, we have an accounting procedure for Article 81 guardians. It's far more elaborate than what we do for 17A. And the appellate division has what they call court examiners who examine the files, including what's happening personally as well as financially. And they have the ability to go to the court and say, this guardian is not doing the job. You need to take a look at what they're doing. And the other thing we haven't mentioned, and I do want to mention it because it's important, particularly in cases like Britney Spears, where there was allegation of mental health issues. We have in New York, and they are part of the appellate division in each department, mental hygiene legal service. And they are by statute authorized to appear in a lot of cases involving people who are committed to mental hygiene facilities, but also in guardianships where the person is in a mental health facility or receiving services from the Department of Mental Health, to appear and act as their lawyer. And they may, if they appear as counsel, they are likely get notice of any kind of subsequent proceedings and accountings, so they can be sort of an ongoing representative of the individual that can play a very important role. And we have a number of people who've graduated from Albany Law School who have pursued careers in mental hygiene legal service. And in fact, Sheila Shea is the director of the 3rd Department, Mental Hygiene Legal Services, and she's alum of Albany Law School. So anyway, just
There was also a question about conflict, and if everybody's getting paid, this is one of the advantages of having a mental hygiene legal service in our arsenal, I guess, is that they're not being paid by the estate of the person. So there is question, at least in my mind, about that conflict. I do believe that people who get into this work, representing people who are seeking guardianship or even serving as guardians or, serving as court evaluators, really want to help people. But at least the appearance of a conflict exists when you are billing the estate, and the maintaining of that estate is appeared to be, people always question, hey, are you just doing this to keep the person under guardianship so you can bill for it? And there's certainly in the 2000s, better than I do, Rosemary, when Judge Kaye's report came out, there was some significant abuses from the private bar related to guardianship and billing under guardianship. So it is not it's not that far in our past that there have been serious concerns about the billing of attorneys related to guardians and guardianship proceedings.
There was, and for those of you, want to read the sorry side of some of this, the Office of Court Administration has a website devoted to guardianship and fiduciary services. And the Inspector General report that Jennifer mentioned detailed how the courts were appointing the old school tie people to serve as guardians, and the guardians were collecting substantial fees. As a consequence of that, the court issued new rules. They're called Part 36 rules of the court rules that limit the amount of fees that attorneys who serve as guardians can collect on a given case and then over a given year, to try to tamp down this idea of, as Jennifer alluded to far earlier, this money-making mill out of the guardianship proceedings.
As we approach the 1 o'clock hour and other calls, we're going to wrap up, and we're going to thank our outside experts and inside experts for sharing their expertise. I want to, and there was one more question I'm going to ask the experts to respond to just really quickly. Well, also, as we look forward into April, and I know it's, happy March 1st, everyone. It's going to be April and spring very soon too. If you have ideas for future topics, please let myself or Professor Reyhan know. And I'm gonna just with that, before we thank our experts, just one final question. If you have a quick response to either Jennifer or Rosemary, what's the standard for better off? Obviously, an entertainer, performer, someone like Britney Spears is better off than many people, at least financially. Is there something specifically that is better off that you could point to, either that you've read about or seen, or in the New York context? Just why someone might be, if I understand the question right, why someone might lead towards conservatorship or guardianship?
Well, I think it's a dangerous and slippery slope, which is why I prefer the standard in Article 81, which is clear and convincing evidence, and there isn't a best interest. Would the person be better off under guardianship? Because I think that if we took a poll of the people on this call, there's somebody else in their life, maybe even a parent, who made better decisions than we did once we turned 18 through and maybe even into where we are right now. So better off is a terrible standard to have to rely upon in a court proceeding. And I do think that many of the conservator guardianship statutes which are built off of that standard predate some of the disability rights movements, and this idea that a person should have that autonomy as a right versus a privilege. So I could always, like any good Socratic method law school course, argue both sides of the equation when you give me a best interest standard like that. And when you see that, I think you see less restorations.
So I'll just say, Ted, I posted a couple of cases in the chat that argue against the better off standard, because they're all involving parents who are saying, I know better than my adult child how they should be living their lives. And the court said, no, no, thank you.
That's great. Thanks so much, Rosemary. For people listening to podcasts, a matter of Richard Doe, case from Nassau County, 1999, and a couple others. With that, we want to get folks on their way to class and other meetings. Jennifer, Rosemary, thanks so much for sharing your time and your expertise with us. On behalf of all our participants, thanks so much for being with us. Thanks so much, everyone, for joining. And Jeff Sieber, thanks for your continued coordination and staffing and support of this event and of our events generally. And thanks everyone for participating. Let us know if you've got topics for going forward.
Thanks, Jennifer.
Thank you.
Thank you both. Bye, everybody.